Good morning. I am Dawn Stark. I'm here live from Laguna Niguel. I wish I could say it was sunny, but we have a little bit of fog. And I'm here to present the first leg of the seminar, and this is entitled, What are Trusts and Main Trust Principles? So to get started, the first section is entitled Trust Terms, Concepts, and Definitions. So I'll go through, you do have something to follow along with, but I'm gonna go through in a way that I would normally talk to my client, and so that you can understand the different terms. The first term is simply, what is a trust? What is this? Interestingly, we tend to, if we say, what is a coffee cup? This is a coffee cup. We can see it. Trusts are not exactly something that you can see, so a lot of times the client is a little bit confused on exactly what is a trust. A trust can, certainly be a document. It can come in and have a big binder. The size doesn't really matter. So is it just a piece of paper? What is exactly a trust? So a trust is really a legal entity. It's an arrangement, essentially, where property is owned and managed for the benefit of somebody else. So as you meet with your clients or as you draft a trust, it becomes a little bit more easy for the client or for yourself to understand. So we'll again go through everything. And as we come full circle, it'll make a little bit more sense. One of the definitions here is settlor. The settlor is simply the creator of the trust. Sometimes, depending on the attorney might choose to use the term grantor or trustor. Grantor, not so much, but typically trustor or settlor, and that's just personal preference. I tend to use trustor, but I've reviewed many trusts where trustor is used in place of settlor, but it really is just interchangeable. The settlor is the creator of the trust. That's your client. That's who you're drafting the trust for. Also important to point out, which I do to my clients, is so that they're not confused. If their trust does say settlor and they're filling out a form later in time that says trustor or grantor, it's perfectly fine. You can still fill out the form. Again, it's interchangeable. As far as the beneficiary is the person or persons that are receiving the benefit of the trust. And then there's a trustee. The trustee is essentially the manager of the affairs of the trust. Okay, and we'll go again into a little bit more detail as we get through. And then we do have the term co-trustee. That's a joint trustee. So a trust may have one trustee, may have co-trustees. That could be two people, a married couple, or domestic partners. That could be 4 people. It could be as many people as you'd like, but a co-trustee is simply just more than one person acting. As far as a successor trustee will just be simply somebody named or then acting after the initial trustee is either has since passed, resigned, become incapacitated. So a successor trustee is a named individual or entity within the trust document that would subsequently serve if the initial trustee is no longer serving. A trustee can also be an entity. It doesn't have to be an individual. So sometimes folks will name, a financial institution to be the trustee of their trust. So that should be noted too. We do have down principal and income. So trust property would be designated as far as what is principal, what is income. The initial assets going into the trust would be considered principal. Obviously, income thereafter generated would be the income, and that's what you have to be cognitive of as what would be potentially taxed. As far as administration, trust administration is just the process of administrating the trust during lifetime and, of course, after the settlor passes as well. Personal representative is really, as I put down, it's a generic term for the person who's in charge of administering somebody's estate. The words executor and administrator, executor is going to be the person named in the individual will, where an administrator is if somebody passes without will, you're going to be known as administrator versus executor. You're doing the exact same things, it's just a different term. Probate is just in a broad sense the entire process of administering the decedent's estate. Certainly there's different branches of court. There's criminal court, civil court. Probate is the area that for trusts and estates, and as well as guardianships and conservatorships and so forth, that's our area of court. And interestingly, it's the probate court, but we also are able to open a probate if need be in regard to the estate. So a probate asset would be something that would be passed, that would pass from the decedent's estate outside of trust. As far as a non-probate asset would be something that, I apologize, it is early, an asset that would pass outside of the trust. As far as the fiduciary duty as it relates to a trustee, the trustee has to act with the highest degree of care. So a duty of loyalty, a duty of care. They're managing the affairs of the trust, so they are held to a high level of a fiduciary duty of trust. Okay. The trustee's duty is going to be to the beneficiary. As far as community property here in California would be assets acquired after marriage. Quasi-community property, which we'll see in trusts a lot, which is somewhat confusing to people, are simply just assets that were acquired while residing outside of the state of California that would be considered to be community property if you were in California. So perhaps something while husband and wife or domestic partners were outside of California and acquired wages and income, whatever the case might be, before they moved to California, or maybe they're in California for a while and moved out of the state of California and then back again, that would be considered quasi-community property. And then separate property would be considered truly the separate property of the individual. Assets acquired prior to marriage, gifts of inheritance while married. There also can be certain things that the married couple consents to keep as separate property or transmutes into separate property. So it's obviously important to know when creating a trust and talking to your client what exactly would be community property versus separate property. Here in California, as a community property state, you're only entitled to devise out 1/2 of your community property interest and 100% of your separate property interest. So again, clients sometimes get confused and they need to be cognitive of the fact that they can't decide on the whole of the community property, but rather only 1/2 are they able to devise out. So I have this slide, and it might look a little juvenile with the bucket, but I think it's easy to explain to a client, again, for somebody to be able to visualize. So I always tell my client, think of the trust as a bucket that can hold your assets. It can hold all kinds of things. We can put real estate into that bucket. We can put CDs, bank accounts, brokerage accounts. There are some things that may not be titled into the name of the trust, but there's more than not. So we can put all these assets into this trust bucket. And who does that? That would be the settlor. It's the settlor or your client's assets that are going to be placed into the trust. How this is done depends on what the asset is. So certainly for real property, that would be done by deed. Other assets, such as a bank account, for an easy illustration, is something that would be updated from Joe Smith to Joe Smith's trust. I always tell my client, don't be too nervous about it. It's similar to just as if you were going to go to the bank with a name change, your last name's changed. And I say that again in a general sense of, we don't want to ever overwhelm our clients, but we have to make sure that assets actually get into the trust. So again, if we don't place assets into our trust, we just have a piece of paper. And that's also what we don't want our clients to end up with, is just a piece of paper that they paid for, that document called a trust. We want to fund the trust, which we'll get into it a little bit later. So again, the settlor will transfer assets into the trust. The trustee would then have the legal ownership, not personally do they own these assets, but the legal ownership in order to manage these assets. So for instance, if a brokerage account was now retitled into the name of the trust, the trustee would be the one that would be signing documents, deciding on as far as investments and so forth, subject, of course, to the instructions or rather terms of the trust. But the trustee would be the one making those decisions, signing checks and so forth. And then the beneficiary is going to be, of course, the one that's receiving the benefit from the trust, distributions from the trust. And then here's my next slide, another slide that again, seems maybe silly, but an easy illustration, I believe, for my clients. I always say, think of it as hats, because the client tends to get a little bit confused and they interchange words, and sometimes they're calling themselves executors when that pertains to a will. And I always say, think of what hat you're wearing and what role you're doing. So as far as, are you wearing the role, are you wearing the hat of the settler? Well, if you're wearing the hat of the settler, you're creating the trust and you're changing the trust when things change in life. And by the way, this presentation today is primarily focusing on revocable trusts. So that's what this, if you're wearing the settler hat, I'm making changes to the trust. It is my trust. If I'm now wearing the hat of the trustee, I'm managing the trust. I'm making financial decisions. Accounting to the beneficiary. I am following the terms of the trust and carrying things out. If I'm wearing the hat of the beneficiary, I'm the person receiving the benefit of the trust. So what is going on, and what position are you in? Think of it in that way. So a lot of times with revocable trusts and your clients, they're going to be wearing all three hats. You're going to have a client coming in that wants to create a trust, and it's, again, a revocable trust. They're creating it to avoid probate, and they're going to be wearing all three hats. They're going to be the creator of the trust, they're going to be the manager of the trust for their lifetime, or if there's a capacity issue, they're obviously can't serve as a trustee. So sometimes during lifetime, they're going to resign, or by virtue of lack of capacity, step down. So again, they're going to create the trust, they're going to serve as trustee, and they're also the lifetime beneficiary of the trust. They're creating the trust, again, to avoid probate primarily. So they're wearing all three hats. The settler hat's not going to change. The settler is the settler of the trust. The trustee hat may change to somebody else, again, by virtue of during lifetime an issue of incapacity, or perhaps the trustee just simply wants to resign and no longer wants that position, or just simply can't do it any longer. And the beneficiary is going to change depending on the terms of the trust, but primarily upon the death of the settler. Okay, I just had a question, and hopefully everybody can hear. Okay, I think so. So again, the settler hat will not change. The settler is the settler. The settler is the one that makes changes. Trustee manages the affairs of the trust. Beneficiary is the recipient of the trust assets. Okay, we have a section about the laws of the trust creation and administration. So as far as the Uniform Trust Code is concerned, California has not enacted the UTC, but essentially the idea behind it was to create a uniform trust code. California was a little bit ahead of the crowd, and so in fact, if you look to the notes there, when the UTC actually referred to some of the California statutes when they were creating the code. But for our purposes, California has not enacted the UTC. And as far as the Uniform Probate Code, additionally, California has not is not a uniform probate code state. We have our own California Probate Code, and that's what you would look to. I did list within the notes different section or divisions rather of the code, but it's easy to, I think it's easily understandable. I don't think it's too tricky to read if you do look up a particular code, but that's what we rely on. So as far as the trust is concerned, obviously the terms of the trust are going to govern the trust, but they also have to be consistent with the California Probate Code. The probate code, a lot of times we're looking to, as far as trustees, if they're not acting appropriately, different duties, things of that nature. The Uniform Principal and Income Act, that was replaced just recently by the Uniform Fiduciary Income and Principal Act. This purpose is really to provide trustees the procedures in allocating receipts and disbursements, so income and principal. Keeping in mind when the, I think another thing sometimes clients are a little bit worried about also when selecting trustees would be, I don't know if this person will understand exactly, what to do and how to account. It's okay if your trustee that you selected doesn't have an accounting background. A trustee is always able to hire attorneys and accountants and financial advisors to assist in the process of administering the trust. But for our purposes, we are just noting that California has the Uniform Fiduciary Income and Principal Act. We also, again, look to the terms of the trust as far as if there's anything specific as far as accounting. Okay, trust revocability and its implications. With a revocable trust, it is just that. You're able to revoke, the settler is able to revoke the trust, to terminate the trust completely. They can amend the trust as many times as they want. I have clients that never amend their trust, and I have clients that have amended their trust 10 times. It's all over the place. As life changes, they change. You amend the trust. Sometimes you'll hear of something called a restatement of trust. That is an amendment, but rather when you have a client that comes in and says, well, I want to change my trustee section because I'm not, crazy about who I've selected. And that's all they want to change. Well, maybe we just do a simple amendment by saying we're replacing section whatever it is with this new paragraph. When they come in and there's quite a lot of changes, or it's been many years, sometimes the better alternative is to restate the trust. What I tell my clients, new and improved, instead of having parts and pieces of going, here's the trust, here's this amendment, the second amendment, the third amendment. We have a new and improved trust, a restatement. So it is an amendment, but it's an amendment of the whole. Do you still keep your original trust and all the amendments? Absolutely. But this restatement is much more comprehensive and much more easy for somebody to understand, rather than a trustee having to go through and look to multiple documents and go, this piece fits in this part of the original trust. So it depends as far as you as the drafter and what the client wants. But a lot of times that's just a more simple method to use. But when creating the revocable trust, again, just to reiterate, they can make changes. Sometimes folks have a hard time deciding who they want as trustees or beneficiary contingencies and so forth. And it's always, I find it best to say, if you pass today, what's the best situation? Because you have to get started somewhere. You don't want people to be held up on, not being able to come up with some sort of a decision, because again, they can always change that. So if time goes by and the folks they named as far as successor trustees are not really a good fit any longer, well, you have the ability to change your trust. So you change it as life goes by. One other thing is that you can secure your assets before death. The trust is operational when the client signs the trust. Different than a will. A will is not going to become operational until somebody passes. A trust becomes operational when you execute the trust. Again, most of the times, the settlor is also the trustee, and again, the beneficiary, and runs the show. But sometimes there's issues of incapacity during the settlor's life. And in that, the nice thing about having the trust is you've already outlined who you have listed as a successor trustee, should you not be able to serve. And you have different parameters within your trust of your wishes. So certainly if somebody's suffering from incapacity, it would be hard to make those decisions at that time. So as far as securing assets before death, you've secured the terms of potentially how those are going to pass, when they're going to pass, if there's any contingencies and so forth. Avoiding probate, that's a big thing when you're, or one of the main reasons why folks are creating a trust. To avoid having a probate open, the easiest way to tell your clients is either by beneficiary designation or by trust. A trust is going to avoid probate. So if assets are titled in the name of the trust and governed by your trust, they will avoid probate. Probate is there for an asset outside of trust. The trust is already essentially titled, the assets got titled in the name of the trust, and the trust has the parameters of what's going on with that asset and who it's going to. The reason why you're going to go to probate is you need some kind of a court order, an instruction, some kind of a legal document that says who this asset's going to go to. Even if you already know it's going to go to spouse or kids, because that's the statutory default of what would happen, you still have to have that piece of paper in order to deal with the bank, whatever property that you're dealing with. So the trust avoids that by already fulfilling that more or less instruction list. You already have the beneficiary listed in the terms, so it doesn't need court approval. So the entity that you're dealing with after somebody passes away is going to be satisfied with a copy of the trust or particular pages of the trust and so forth. Avoiding unnecessary hassles. This can help in eliminating, if a client didn't have any estate planning documents whatsoever, this can eliminate the fighting between children, relatives, and so forth, because your wishes are already laid out and hopefully they're very clear. I do have a lot of clients that say, can I put this term in the trust? Can I be more specific on this? The answer should always be yes. It's their trust. It should be their custom trust. And it is good to spell things out, especially if you anticipate some issues later. So there's very few times, actually, I don't even think I've had one, other than my remembrance back in law school of a couple things that we were not allowed to do as far as against public policy. But otherwise, as far as folks wanting different terms within their trusts of one of my children is not going to receive money until they're X age or only for this purpose, things of that sort, yes, it all can be put in there. It's your trust. You create the terms of it. Allowing for ongoing financial management. So as the wealth accumulates, again, they're protected within the trust of having the possibility of an asset going to probate. So perhaps the asset was small at one time, but hopefully that asset will grow in value. As far as trust funding basics, this is huge. Again, if the client leaves and they've signed this trust and that's all they've done and they pass away, they have a piece of paper. You have to fund the trust, and by funding the trust, that means titling the assets into the name of the trust. A lot of times, I myself, I will always do the deed work, so I will place the real property into trust. I can't physically go and I can help my client, but I can't physically execute a document to place their bank accounts and so forth. That's something that they're going to have to do. So that's a part where you're going to instruct your client by virtue of a meeting, a memorandum, whatever you're going to give them of how do you get these assets into trust and what assets are allowed to be titled into trust. That is always good to follow up with them. Again, the idea is if you spent the time and energy to create the trust, let's make sure it's funded. You'll also run into sometimes clients will say, well, I'm not going to put this asset into trust. Well, ask the question why? Why not? Oh, it's a small asset or this. The idea is, again, you've created this trust, get the assets into the trust so that it can be administered properly upon passing, or again, in the event of incapacity. It's going to be a much smoother process if the assets are funded during lifetime. An initial schedule of assets and subsequent routine follow-up. Not all attorneys create this. I personally do. At the end of the trust, there'll be a Schedule A and potentially a Schedule B and C. If it's a couple, Schedule A is going to have a list of the assets. That needs to be updated. It doesn't have to. It's encouraged to be updated with the assets. One gives the successor trustee an idea of what they're looking at, what assets they're going to be managing. But it also shows intent should that asset fall out of trust, or if it didn't make it into trust for some reason, it shows that the settler's intent was that it was supposed to be a trust asset. That is a page they can actually write on. The rest of the trust, if they want to amend, has to be formally amended, but the trust schedule can be written on. So let's say they have a house at ABC Street, but they've sold it. They can cross it out. They've acquired a new house. They can write in the new home, so long as it's titled in trust, and write that portion in. I have a lot of clients that I don't see on a regular basis, but they send me in their new schedules just so I have it in their file, and that's their prerogative of whether or not they want to do that. But again, the idea is to fund the trust to avoid probate. So if you have a trust, it's not been funded, you're in probate court, or your estate is after you pass. As far as a revocable trust protecting from creditors, during lifetime, a revocable trust is really the same as you or I with trust at the end of our name. Uses your social security number for tax purposes. A lot of time, there's different trusts that are out there that serve different purposes, but a revocable trust is not going to protect the settler's assets from a lawsuit or from a creditor claim. If you have a credit card, or you have a judgment, things of that sort, your assets are not protected. A revocable trust is not the vehicle to protect those. So during settler's lifetime, those assets are subject to creditors' claims. After death, the trustee's duty, of course, is to manage the affairs of the trust. The trustee will know of some of the creditors. Some of them perhaps they'll find out over time. But it is important to make sure that the debts are paid. As far as the duties of the trustee to pay the liabilities, it is the duty to pay all the liabilities. And I've never seen a trust where it says that you can make a distribution to the beneficiaries prior to, paying out all of the liabilities. That doesn't mean if there's a very large trust that you could, in the process, make smaller distributions. But the idea is you're not going to make a distribution out to a beneficiary of money that needs to still be in there to pay for liabilities. Let's see. As far as the beneficiary's personal debts, a lot of times a trust will have what's called a spendthrift provision. So if in a case, let's say we've named our children as far as beneficiaries upon our passing, they're not going to be able to attach their personal, just by nature of them becoming a beneficiary at some point, they can't use that potential inheritance as far as taking for loan purposes, for creditor issues, and things of that sort. In fact, because of the spendthrift provision, which is found in most trusts, the idea of it is just that it's to safeguard the inheritance rather than having somebody be able, or a creditor being able to attach to the trust. As far as the trustee's duty to pay out a beneficiary, you have to look closely at the language. So sometimes the language says that they have discretion as far as distributions, and some are mandatory distributions. If there's mandatory distributions, the trustee has to make those distributions. Once those distributions are made, the money is free game. It's now in the hands of the beneficiary, and there's not much you can do. If there are clauses within the trust that spell out that the trustee has the discretion to make distributions, you have obviously more flexibility. But never say never. Anybody can petition the court, and if they're successful, they can compel the trustee to make a distribution for something. As far as claims, the trustee can, if something comes into the trust, as far as even a credit card bill, the trustee's duty is to look thoroughly at it. Is this accurate? Is there money here to pay it? They're going to approve or deny it. They're going to ask for supporting documentation if need be. In the case where there's potentially insolvency, you know, what do you do there? That's an area where you are going to go ahead and look to the probate code, and there is more or less different classes, and you start off with expenses of administration, different next categories, obligations as far as mortgages, deed of trust. Then you have funeral expenses and medical, family allowances, and so forth. And you start with the first classification, and this is probate code 11420. And you would go through, if you only get to the second level of classification and you're out of money, well, then you're out of money. If you don't have enough money for that particular class, then you're going to go ahead and pay out pro rata of what's available. You can also petition the court to declare an estate insolvent if you wanted to. But if there's no money to pay the bills, there's no money to pay the bills. As far as considerations on whether or not a client needs a trust, again, to avoid probate is huge. Privacy. A trust document is private. Interestingly, I do have a lot of clients that say, okay, now I need to record the trust, don't I? No, you don't record the trust. If you record a trust, it's public knowledge. So that is an attribute of having the trust. It's private. Now, a settlor can share the trust with whomever they feel comfortable with, but otherwise nobody has access to it unless you've provided that trust to the individual. Do you need to provide a trust to certain legal entities in order to title assets? Sometimes, or sometimes you can just execute a document called a certification of trust, which just has the basic information that that entity would need. Sometimes you can just pull parts out of the trust that would apply to whatever you're doing, or if you're titling assets, those particular sections. Sometimes I have clients that don't care; they're fine with sending the whole trust, but it's really, you know, up to the client. As far as incapacity, which we talked about just in brief before, the trust is great to have because it spells out what should and allows the trustee to continue business as usual in the event of incapacity. If you don't have these estate planning documents, a lot of times the only other alternative would be to go through probate and obtain a conservator. As far as control and flexibility, again, you can change the management or your ultimate beneficiary designations and so forth during your lifetime with any type of specific instructions that you think are appropriate. When we have complex family dynamics or blended families, it's also useful too because everything's spelled out. And again, as far as community property, sometimes in those situations, the community property is one half will go to the children of one side and the other, and respectfully to the other side. And so there's flexibility in that. And then as far as out-of-state real estate, sometimes that will also help as far as owning property outside of the state of California, as far as having to open different probate proceedings. As far as somebody came in and didn't have a whole lot, it's not mandatory that, you know, of course, everybody has a trust, but we do have, if somebody passed with a smaller amount of money collectively, right now that's about roughly $185,000. A formal probate would not be necessary, and there's there's affidavits of small estate value that can be done in order to avoid a probate. And so those folks maybe just are fine with coming in and just having a will. But they do want to be cognitive of, again, as things grow, they don't want to be over that amount. Sometimes people get confused and they just think it's one asset, but it again is collectively. So if the client has collectively, it's not taking every single asset, is it under the 185? It's actually 184.5, but if it's under that amount, but again, collectively. And anyone with real property in California is probably going to fall in the lines of needing a trust because of the cost here. Okay. All right. Well, we have a little bit more time. So I have a question, and it's more in as it's again the question is, how would you distinguish between a trust beneficiary and a trust settler in the context of a charitable remainder trust? That's a little bit more complex estate planning. So the purposes of today was to keep it simple, and I believe NBI does have actual seminars that would be related to irrevocable trusts themselves, and specifically on charitable remainder trusts. But again, the settler is always going to be the individual that's creating the trust. Okay. Okay, I'm just looking for questions. Since we have a little bit more time, just a few other things I can point out. As far as successor trustees, again, those are the folks that you're going to name that would take the place if the initial trustee can no longer serve. Important, I think, to always name a handful of people. I always say think of 3 people or 3 groups. And the reason being is because we don't know if our trust hadn't been amended, if somebody's since passed away, if they came on as into the trustee position and thought, wow, this is too much for me, I want to step down. We always want to avoid going to the court. So it's always nice, I think, to have a handful of people named as opposed to just one successor trustee. So that's just the practice I follow. I try to get somebody to name 3 successor trustees: first successor, second successor, third successor. And then there should be something within the trust that would also designate that in the event of a vacancy, are you going to name an individual that could find a suitable trustee? So let's say for whatever reason, everybody passed away or nobody wanted to serve. Now what? Again, always trying to avoid going to court to have the court appoint somebody or find somebody that would be suitable, and having to expend the time and money going through a court proceeding. So that's just something else to think about. And this question says, what are some tips for new attorneys trying to break into this practice area? I think that's an excellent question. And I would find probably a mentor attorney, which is actually what I did initially. Interestingly, my mother's trust attorney was sweet enough to say if I ever wanted to go in this area of practice, to contact her. So never be afraid to reach out to somebody that you know or somebody that might want to serve as a mentor attorney. So as you're drafting begin drafting trusts, and you should always start with just drafting revocable trusts. Don't jump into drafting irrevocable trusts, because you have to really understand how the revocable trust works before, and some attorneys just simply do more simple estates rather than more complex. But I think by nature of starting small, listening to as many types of these types of seminars, and maybe even just working alongside another attorney if possible. But as far as if the question is more aligned in finding clients and so forth, I can tell you what I did, and that was simply going out there and word of mouth and meeting people. Unfortunately, as attorneys, we're kind of a dime a dozen. My personal opinion is advertising is a little bit hard, especially starting out. People have to get to know you and feel comfortable with you. And I also think if you're interested in later on moving towards also litigating or probate, it's really interesting if you end up, there's a lot of attorneys that just simply draft, but if you end up litigating, it really is interesting because these terms that you read on paper play out much differently in court. And so it's very helpful if you're able to later on start going to court, because it allows you to draft much better documents, because you know what could happen, or you might know by virtue of litigating a case, I need to put in this extra language because this could happen in a worst case scenario. So I would encourage, if that's something of interest to you, and it doesn't mean you have to take 10 cases a year, but it's a good way to really gain additional understanding of how the trusts work. And sometimes they play out differently in Orange County than they do in LA County and so forth. So it's pretty interesting to see what works in different places and the flexibility, because probate is a court of equity. So the judges have a lot of discretion. Another thing as far as drafting, I feel that it's good to give examples and so forth in your drafting, so that you don't have a judge that doesn't know your family to make a decision on what your wishes are, because you'll be passed away at that time. So I guess that's my 2 cents on that. And then I have one other question. What are the essential elements required for a trust to be valid in California? I have 2 minutes left. The trust has to be formally executed. So that means it's going to be notarized. It'll be signed. You're going to, again, have your settlor, your trustee, and your beneficiary designations within the trust. But as a will is witnessed, a trust in California is notarized. By making amendments, you're going to do that in the same way. It'll be formally executed. So sometimes folks think they can cross something out or put a little initial. It doesn't work that way. It needs to be done formally.
Awesome.
Okay,
Thank you so much, Dawn.
Thank you, and I hope this was helpful. And if you do have any questions, I am always available to reach out on my section if you have something that maybe comes to mind at a later time. So thank you.